SJC-13148, Commonwealth v. Edward B. Fleury.
Okay, Attorney Robinson.
Good morning, Your Honor. I'm going to remove my mask pursuant to the standing rules. May it please the court, Tom Robinson for the appellant, Edward Fleury. At issue in this appeal is whether the legislature intended the forfeiture provision under General Laws Chapter 276(3)(b, governing property seized by search warrant, whether that should apply to firearms that are improperly stored. The words in the statute that create the ambiguity in this case are the words unlawfully kept. If we look to the intent of the legislature in determining the meaning of these words and whether
Let's start
improperly...
with the plain and ordinary meaning. Why is not something that has found to have been kept or stored? Or that is, let's just look at the language of the statutes themselves before you get into the legislative history, if you might.
Yes.
The language of the forfeiture statute says found to have been kept, and your client has been found guilty of a violation of the keep and store provision of 131L. Why is that just not a plain and ordinary meaning?
Well, if you look at the entire language of Chapter 131.131L, the word keep does not stand alone. There's a modifier to
Right,
that.
so found to have been kept is broader than keep under 131L, right?
Yes.
So why isn't 131L's subset of the type of keeping something that is included in found to have been kept?
Because under 131L, it is, as I was saying, not just found, but found with the modifier in any place. And
So a subset of keeping.
yes.
You can keep it here, or you can keep it as 131L says.
I would agree. I would agree that storing would be a subset of, or included within keep. But I would suggest to you that had the legislature intended in the enactment of 131L to include stored firearms, they could have simply added the word stored.
But if found to have been kept is a broader thing than store or keep than in 131L, why would the legislature have found need to amend Section 3B? It's already included. It already includes the subset of keep and store that is unlawful under 131L.
Well, I would suggest to the court that because the intent of the legislature at the enactment of 276(3) could not have included storage at that time. So to erase ambiguity, what should have happened, if that was the intent, was for them to put the word store in there. And if there is any ambiguity about whether or not the words unlawfully keep encompass stored, I would suggest to the court that the rule of lenity demands that ambiguity be resolved in favor of the defendant.
What's the purpose of the forfeiture law to begin with? Was there anything in the legislative history that you found for why they passed the forfeiture law?
In terms of the history of 276(3), as I outlined in my brief, it would appear that the first iteration that we have is in 1835, Chapter 142, Section 5. And from the language of that, it would appear that the legislature at that time was primarily concerned with stolen or embezzled property and the return of stolen or embezzled property to its rightful owner. And it didn't contemplate seizure of property as a result of items that are used in wrongdoing. And it stayed that way, and in fact had language in it suggesting that property could only be forfeited if it was found to have been used in the commission of a crime. It stayed that way, I believe, until 1964, when we get this amendment to the language of the forfeiture statute, which includes what I would suggest is the problematic language at issue here today.
Do you understand, what was the purpose of the amended statute? Was there anything in your, in the legislative history that explained why they amended it to be a little broader?
Not that I was able to find, but as I outlined in my brief, at that time, there were about 4 statutes that dealt with different types of illegal possession of a firearm. And so it would seem that that language, unlawfully keep, was meant to address situations in which someone was actively possessing a firearm in contravention of the law.
And you're suggesting this is a passive possession in contravention of the law, rather than an active one?
I would suggest that the words are very important, Your Honor. I would suggest that if we look to the history, the etymology of the words keep and store, it is instructive and goes to exactly what you're talking about. The word keep, according to the Oxford English Dictionary, the unabridged version, suggests that the origin of that term was originally construed as a genitive, a case of nouns or pronouns indicating possession, such as the word my. It then first begins to appear as a word in the Middle Ages. We have the word seped that appears in a text of homilies from 1175.
Do you think the legislature was consulting that?
I don't. I think it's just, I draw this historical distinction between the words store and keep to suggest that there is a very significant difference between the two words.
Right, as in you're supposed to store it properly and don't keep it with improper storage. No?
Well, the history, the etymology of the words, I would suggest, indicates that the word keep generally implies some form of present possession, whereas storage, or to store, implies leaving in a place. And the language of 140, section 131L, would bear that out because, as I said, there is that modifier within that statute in a place.
Going back to the Chief Justice's question about the purpose, if you look at the entire statute of Section 3, it deals with items seized in search warrants and also diseased animals and the like. Would a proper reading be that we don't want people to have bad things, contraband, diseased animals, they're going to be destroyed? And in this situation, we don't want people to get an illegal gun back. This is different, I think you're arguing, because your client can cure the problem by having a lock, correct? I'm trying to draw the distinction, or asking you if there's a distinction between contraband and items that are not contraband.
I would agree. I would agree, Your Honor. So generally speaking, there was contraband, and as I said at the initial enactment of 276.3, we're concerned with stolen property. And so, and up until 1964, only contraband or stolen items would be subject to forfeiture. And 131L, an improper storage, is unique because it is not contraband in the sense that it's unlawful property. It's property that's lawfully owned that has been determined not to be properly stored, which is a legitimate concern of the Commonwealth, of the courts, and of the legislature. But I would suggest to you that if there is going to be a penalty of forfeiture, it should be explicit in the general laws and not something that is inferred.
That may be true, but does the rule of lenity apply in the forfeiture situation? You referenced the rule of lenity earlier.
I think that's a very good question. I would call the court's attention to Commonwealth versus Dayton, 477 Mass 224. It's a 2017 case which deals with the pretrial detention under 276-58A. And so that's not a criminal law in the terms of looking and analyzing a criminal statute and whether something is lawful or not. That is much more procedural in nature. And I would draw an analogy to 276, or excuse me, I would draw an analogy to 276-3 in this case. Another case.
To address the Second Amendment issues at all, and whether or not your client is raising any issues regarding that constitutional provision?
We are not, Your Honor. I agree with the Commonwealth in their brief. My sense of Article 17 of the Massachusetts Declaration of Rights is that it's not implicated, in that it only provides protection for the right to bear arms where the militia is implicated. And then if you look to Scalia's dicta in Heller, which gives us an indication that the Second Amendment is not implicated, the rationale there is that it's not implicated because forfeiture alone would not prevent a person during the founding era from possessing a gun. I think the implication is they could just go get another one. So in that dicta exists.
Does that make sense, though, really? I mean, if is he really going to be able to get another gun? If the founding era, we didn't have all these rules about getting guns. We have all kinds of new rules about getting guns. If someone's had to forfeit their gun, are they likely to get another one? I'm not sure I understand that.
I think Scalia would suggest that if that individual was involved in a militia, or if there was some type of need for action, that a gun could be made available to that individual.
I'm confused because Scalia writes the decision that says you have the right to a gun in you do have the right to protect your home, right? So you have a right to a gun in a home. I'm not, they weren't dealing with storage. I'm just wondering whether, the distinction here between storage and keeping has some Second Amendment issues related to it. Because again, the distinction Justice Gaziano was talking about earlier between, storage may be more limited. I'm just not sure I follow why there isn't a Second Amendment issue here. If you're not raising it, we don't have to wrestle with it, but.
Your Honor, I don't disagree in the sense that the right to bear arms is enshrined in the Constitution, and it is considered a fundamental right. But unfortunately, from my perspective, the case law would suggest, certainly for Massachusetts, that the Massachusetts Declaration of Rights is not implicated. And in terms of what we have from one of the court's most conservative justices, we have language directly on point suggesting that a law governing the forfeiture of firearms would not implicate a Second Amendment right.
Okay. You all set? Thank you.
Thank you.
Attorney Von Flattern.
Thank you. Good morning, Madam Chief Justice, members of the court. Assistant District Attorney Cynthia Von Flattern for the Northwestern District for the Commonwealth. With respect to this defendant, the Commonwealth would ask that the order of forfeiture be affirmed, that Chapter 276, Section 3B applies to the weapons, in this case, to the 12 guns for which the defendant was convicted. There were...
I'm a little confused by this, because, so, 276, Section 3 is written well before the storage. At the time it's written, storage is not illegal, right? We don't have any legal requirements about storage.
Correct. It predated the storage statute by about a century and a half.
So it wasn't even focused on storage. The idea of improper storage couldn't result in a forfeiture back then, right?
Well, I mean, the statute always said unlawfully kept, used, or concealed, but there was no statutory, there was no offense for, there was no requirement to keep one's gun under, under a lock or locked, so there wouldn't be.
And then when the legislature passes 140, Chapter 140, 131, they create a distinction between store and keep, right? We got to have some meaning to that, right?
Well, they do say store and kept, Your Honor, and normally...
They say store or keep.
Store or keep, and normally we can infer that they're not going to put in any extraneous words.
Right.
So we would infer that it could mean two separate things, but it can also mean, the Commonwealth argues, that the legislature is familiar with its own statutes, and that kept would definitely be included within 276, Section 3. And oftentimes, with respect to one's...
But if that's the case, why didn't they just write keep? It shall be unlawful to keep any firearm. If it encompassed it, why did they need to draw the distinction between storage and keeping?
I think that store is a type of keep, and sometimes, thinking about holding on to one's gun, one could have it in a more permanent storage and have sort of constructive possession of it in one's home or even in one's barn or office or something, and that, or they could have it, closer to them, and that might seem more like keep, so that store does imply some future use, but it's still a type of keep, and it can be very fluid with...
Yeah, we have very particular storage requirements, right? I mean, I can't remember them, but they're very detailed, right?
Yes, that there have to be a trigger lock or that they be kept in a secure container, but I think the case law shows that, when you're looking at the constitutional implications of the storage of Chapter 131 or Section 131L itself, that there's no Second Amendment violation because a person can get quick access to their gun. It's kept. It has to be secure, but once
not if they're destroyed.
Yeah, what about the due process part of this case, where I assume this gun collection is very valuable, correct?
I assume so, yes, Your Honor. And
Right.
there were many guns for which the Commonwealth did not seek forfeiture because the defendant did have many of them lawfully stored and
Right.
also was
So
acquitted.
Let's go to the parade of horribles. Somebody has 20 firearms. They're all kept without, improperly kept, and they have a valid license for them. And these are valuable weapons. Some are, relics. And the government comes in and says, all right, we're going to charge you because you don't have trigger locks. Fine, the person is charged. Then the government says, and we're going to take this $500,000 worth of guns, and we're going to melt them down and destroy them.
Well, first there would have to be execution of a search warrant.
All right. Indulge me on my parade of horribles, all right? So we get to that, but the point I'm saying is, and it goes back to what the chief had asked, what's the purpose of the forfeiture? I just thought it would be, we find you with an illegal firearm, you don't have a license for it, you don't get it back.
Yeah.
We're gonna destroy it.
Right.
But this is, we find you with the Italian-made Beretta, Benelli shotgun, you don't have a trigger lock it, now we're gonna take it and melt it down.
I think that the storage law, and this court has said that there's a concern with weapons reaching the hands of unauthorized users. So on the one hand, there was a question about, is there a distinction between when guns were seized because they were contraband? There have to be execution of search warrant, but they're contraband, they were illegally used. And so I think that there's maybe a conception, unlawful storage is not as serious, but it was part of the enactment of a body of law that was concerned with gun control, and there is a concern in the case law. But
The person might lose their license, but then the question is, do they get the economic impact of having these valuables destroyed?
well, there is certainly there is a loss of property, but there is also there has to be a finding that there was unlawful storage to begin with, and in this particular case, the defendant was convicted.
Because if we go through the statute, and if you go to the preceding section, you don't get your bad meat back, right?
Right.
You don't get diseased meat, so
Right.
that clearly gets destroyed.
And there could be other weapons that don't have as great a value as guns do, and so there's probably not very much concern raised about that. But there is, I think, guns are placed in a category of these are dangerous, whether they were unlawfully concealed, unlawfully used, or unlawfully stored. There is a serious concern with people being able to get those guns. And if there's been a conviction for unlawful storage, the potential has already happened. That's already been shown to have arisen because of unlawful storage.
Is there any part of this record that says whether or not the defendant lost his license?
Well, he's a felon, right?
He is a convicted felon, or a felon, and so that since the time of the Second Amendment, all of the case law would say he has no Second Amendment right. That right has been lost.
Is that part of the record, though, what happened to his license?
Well, I think this court can, it's clear on the record that there has been a conviction, and that the Commonwealth has only gone forward with respect to the firearms that were the basis of the conviction. So, and the statute for which he was convicted was a felony. It was unlawful storage of large capacity.
Okay,
weapon.
so he can't get the weapons back.
Correct.
Then the question becomes, what happens to the economic value of his weapons, right?
Right. Well, and he has been convicted, and this is the provision in the statute is for forfeiture.
Counsel, can I follow up on, I guess, the Chief Justice Budd and Justice Gaziano's point? Because we know that we don't construe these statutes to reach absurd results. There is an issue that I have that I can't seem to make any sense out of the storage statute. The last line or the last sentence of the storage statute that talks about it doesn't apply if it's kept on your person or within your control. I don't have the exact language in front of me. But again, assume for the sake of argument, all of the stuff you're talking about, they're there to execute a search warrant, and whomever it is has a lawful right to carry, and they happen to go to the bathroom, and they put the gun down on the counter, and just as the warrant is now being executed for something unrelated, they happen to notice that the person put this gun on the counter as they went to the bathroom. So now it's not within their control, but there's nobody else there. It's just that person in their own home. The warrant's being executed, and they go to the bathroom and they leave the gun on the counter. So that person now is subject to forfeiture?
Well, I think that this is a parade of horribles, and in that particular case, I would submit there would not be, there might not be prosecution of that person for unlawful storage. I mean, you might not believe that it happened that way. You have cases where, oh, I just did something or other and my gun, the gun was under my control, but it really wasn't. I think Patterson is one of those. The gun was upstairs in the pocket and the defendant was downstairs. So if it was something very accidental or very momentary, that does not seem like a good case for prosecution.
Is there anything in the statute that says accidental or momentary?
No, but it would be the Commonwealth's burden to show that there was a violation of the statute.
Understood, but again, going off of this reason why I can't understand why there isn't this distinction between contraband and no contraband, because in that situation, the person hasn't done anything other than left the gun off of their person, unstored or unsecured. Right. And if they're executing a search warrant and they see that, I understand you're saying as a matter of prosecutorial discretion, right, the prosecutor might not bring that case, but assume that they do. That person could have their firearm forfeited because it's not stored and it's not locked, right?
Well, and again, I think it goes back to the defendant's defense would be that there was not, that I did have it under my control. I may have gone to the bathroom, but it was still under my immediate control. I mean, that's the distinction in the statute. Such weapons shall not be deemed stored or kept if carried by or under the control of the owner or other lawfully authorized user. So, right. So there is a factual issue there. Whether it was still under his control. And if it was under his control, there would not be a violation of the statute. There also, I think, in this particular case, the Superior Court judge decided the motion for forfeiture. And I think that within Chapter 276, Section 3, we look at whether there was error. So there is, if upon review of the judge's order, there was error, I think that's within the statute. So I believe that there is some discretion within the statute in that first paragraph of Chapter 276, but Section 3.
This is a question of law. We don't owe any, there's no weight to the Superior Court's judgment on we review this de novo, right? There are no facts that were found, correct?
Well, I think that the facts that were found here would be that the defendant was convicted. There's a fact that he was convicted of these 12, storage of these 12 firearms versus the others, for which he was charged, and they were seized, but they have been returned to him.
But we have a judge looking at a novel issue of statutory interpretation with no guidance from us, correct?
Yes, and that's why the issue was stayed. The parties agreed that it would be stayed pending the appeal of the defendant's actual conviction, and then it has still been stayed so that the defendant could appeal his motion for return of property, denial of the motion for return of property.
If I could go back to the statutory interpretation for a moment. At one point you said that stored is a subset of kept, which raises the question of why you have stored in Chapter 140, Section 131L, because as we've talked about, you don't have stored in the forfeiture statute, right, which leads one to think that stored has perhaps a different meaning than kept. And I can't understand why you'd need to have stored if you're correct. It's a subset of kept in Chapter 131.
It does seem to be a subset, Your Honor. I think store does imply some future use. And as I said, I think that they can be very fluid. So you can have something more like kept, and then it becomes more like stored. So. But we know that kept under one's control is different. That implies immediate use. So, but I think that we can also say that where they are so similar and they're kind of fluid, the legislature, we can infer, knew of and was aware of Chapter 276, Section 3, and the language within that statute. But they are a little different, and they certainly did include store as well as kept within the statute.
Counsel, has the defendant made any sort of takings argument? That the forfeiture statute is a taking?
No, Your Honor,
And what is the process that has been afforded to the defendant under the forfeiture statute? Describe to me what kind of process for due process purposes before they take, the weapons are taken away? What has happened?
well, there was a motion for return of property under Rule 60, and then there was a hearing. And so,
So there was notice and opportunity to be
Yes.
heard and a decision?
Yes, it was not automatic upon conviction. It was not, or even upon acquittal. You know, they first determined that there had to be conviction and affirmance of that conviction, and there was notice and opportunity to be heard. There was memorandum on the subject as well. And I would submit that first paragraph in Chapter 276, Section 3, that would give some discretion to the judge.
Okay,
There.
thank you.
Thank you.